Start. The standard of proof is the same as in a criminal trial. Stop. Secondly, even if the nature of the trial of an election petition is not the same in all respects as that of a criminal trial, the burden of proving each and every ingredient of the charge in an election petition remains on the petitioner. Stop. If a fact constituting or relevant to such an ingredient is preeminently within the knowledge of the respondent, it may affect the quantum of its proof but does not relieve the petitioner of his primary burden. Stop. Para. Another argument of Mr. Bindra was that the corrupt practice in question should not have been found to have been committed, as the election petitioners did not examine themselves during the course of the trial in the High Court. Stop. There was, however, no such obligation on them, and the evidence which the election petitioners were able to produce at the trial could not have been rejected for any such fanciful reason, when there was nothing to show that the election petitioners were able to give useful evidence to their personal knowledge but stayed away purposely. Stop. This court observed thus. Stop. Para. It is now well settled by a large catena of the authorities of this court that a charge of corrupt practice must be proved to the hilt. The standard of proof of such allegation is the same as a charge of fraud in a criminal case. Stop. Para. The sum and substance of these decisions is that a charge of corrupt practice has to be proved by convincing evidence and not merely by preponderance of probabilities. Stop. As the charge of a corrupt practice is in the nature of a criminal charge, it is for the party who sets up the plea of undue influence to prove it to the hilt beyond reasonable doubt, and the manner of proof should be the same as for an offence in a criminal case. Stop. This is more so because once it is proved to the satisfaction of a court that a candidate has been guilty of undue influence, then he is likely to be disqualified for a period of 6 years or such other period as the authority concerned under section 8A of the Act may think fit. Stop. Para. By and large, the court in such cases, while appreciating or analyzing the evidence, must be guided by the following considerations: the nature, character, respectability, and credibility of the evidence. Stop.